We're talking about investors right now looking forward to big deals to come. The Justice Department might have unintentionally, maybe intentionally, put the kibosh on that by saying that it's going to protest or fight and challenge in court that planned merger between AT&T and Time Warner. But it put a chill for a while on any and all in and around the media sector on the belief that while those mergers might not be denied, they could be significantly delayed, or could they? Let's talk to antitrust lawyer David Balto on this. David, what do you think?
Neil, I think that's a significant concern, not only in media, but also in healthcare. And this deal will raise risks in deals like Luxottica, Essilor, and CVS Aetna. Those lawyers and companies have to go back to the drawing board to figure out how much risk they really face and whether the Justice Department will take them to court, too.
Now, when the Justice Department challenges an industry, we always seem to look at it as political, yet it was in Ronald Reagan's Justice Department, memory serves me right, that you had the breakup of AT&T. So what drives these things? Or could it be Donald Trump, no fan, for example, of Time Warner key component CNN, that he didn't want to see that go through, didn't want to see CNN part of the beneficiary of that, and made it very clear that it would be a good idea the Justice Department pursue this. Now, we don't know what the truth is. We do know the Justice Department is opposed to this deal. But what do you make of the role a White House can play, has played, will play?
Well, Neil, regardless of the role of the White House, ultimately a federal court judge has to decide based on the facts before him and the law that ultimately consumers are going to be harmed from this merger. And the Justice Department has a really tough case here. They haven't successfully gone to court since the Nixon administration to block a vertical merger. In fact, no vertical merger case has been brought since the Carter administration.
So what happened in the case of the AT&T breakup at the time? That went back and forth of legal challenges, but maybe that is an interesting precedent here.
Well, yes, it is. And what the DOJ believed was that having a monopolist in all these different aspects of the market led to higher costs for consumers and less innovation. Of course, the market is remarkably different now. And one problem with the Justice Department case is that they've taken a teeny snapshot of competition. And really what you have to look at in a dynamic market like this is, where is competition going? Does AT&T really have the power to foreclose competition when programmers and content providers have so many more alternatives to get their products to the market? Yeah,
I always sense that in the moment we forget that, or regulators concerned about monopolies forget that. I can remember when they were worried that Netscape was taking over the world, and when I mention that to young people now, they say, "Net what?" And we used to worry about dominant players like AOL on the internet, or even prior to that, Prodigy, that have some apparent birthright to constant monopolization of an area, and they're afterthoughts today. So, in this case, how do regulating authorities go on this, and ultimately what prevails?
Well, ultimately, Neil, history predicts the future. And what's the problem for DOJ is that there's not a strong history that suggests that the kind of anti-competitive scenario they've described in their complaint is likely to happen. There isn't evidence that distributors have been able to foreclose competition in the fashion that they describe. It's funny you mentioned AOL. I worked when I was at the FTC on the AOL-Time Warner merger, and all the concerns we had in 2000 when we brought that case disappeared relatively quickly because technology and the forces of competition changed the market so radically in a short period of time.
No, David, you're so right about that. And that's why I always wonder, when you judge the value of this particular transaction, that is AT&T with Time Warner, whether it gets rid of key components or not. Think of all the big players today like Facebook and others that are growing exponentially much faster and are already, in terms of value, much bigger. So how do regulators deal with that? How would a court deal with that?
Well, what a court's going to do is it's going to talk about what's the likely future competitive impact. And that's where taking a snapshot of competition right now might be deceptive. The court's going to have to look how these other forces, Facebook and other firms, Netflix, et cetera, how are they going to change the nature of competition? And if you just look at the time period between the Comcast case that the Justice Department brought and now, competition has changed a lot. And that upper trajectory of competition is going to continue to occur regardless of whether or not this merger happens or not. And I think that's going to be crucial for the judge in determining whether or not consumers were harmed. It's hard to explain how consumers are going to be harmed by this deal.
Yeah, no, you raised good points all. David, thank you very, very much. Have a great Thanksgiving.
Thank you. Same to you, Neil.